collaborative and similar.
You think the Monkey King?
Of course, the Monkey King is in Indian legend. And also in the
Chinese legend. 西游记里面孙悟空. Well, the question is, do you remember what Sun Wukong, right, the Monkey King, was trying to learn from from his master? Do you remember that? So, yeah, 悟空和这个菩提大师. Do you remember? Longevity, forever. So Monkey King, all he has been doing, he wants to live forever. Now, not all of us want to, live forever. So do you remember what he learned in order to live forever? Do you remember, any of you? The skills, the specialties that he learned in order to live forever.
transformation.
Yes, exactly. 72变, right? 72 transformations. 孙悟空72变. So if you want to live forever, you have to adapt. You have to change. You have to transform. I suppose that's the message that I would like to, setting up the background. If you want to live forever, you have to learn how to change, how to adapt. 72 transformations. You can see that on the left, Wukong turned into a tree, right? That's a very well known scene in the TV series back in the time when I was little. Okay, right. So, what makes arbitration inherently collaborative? Well, although we like to think that the way that we've been used to, we've been conducting arbitration has been quite adversarial, I think, overall, generally speaking. But I think there are at least these three aspects that I believe that would demonstrate that arbitration is actually inherently collaborative. First of all, as we all know, arbitration is a consensual process, right? It can only take place if parties agree to submit their disputes to arbitration. So it's based on a consensual agreement, arbitration agreement. Secondly, arbitration should be conducted according to the terms of the parties' agreement. So typically, the parties would designate a set of rules, right? Or they would designate an appointing authority to appoint the arbitrator, and then that arbitrator could decide the rules to follow. So therefore, the proposition is that if the parties agree to conduct the arbitration in a collaborative manner, in a collaborative way, then surely that agreement itself is binding and should be given full effect. Okay, so if they agree to conduct the arbitration in a collaborative manner. Now, thirdly, in an arbitration, the parties choose their arbitrators, and according to their designated arbitration rules I mentioned earlier, or they can designate an appointing authority. So therefore, if the parties agree to choose a collaborative arbitrator to resolve their dispute, then again, that agreement itself should be binding and should be given full effect. So we're talking about you have the arbitration agreement and you have the agreement to conduct the arbitration in a collaborative manner, or could be, by way of adopting a collaborative protocol, for example, so certain procedural rules. Or the parties could simply agree to appoint a collaborative arbitrator. Now, in a world, we have so many arbitrators that might help some arbitrators to stand out and say, hey, I'm a collaborative arbitrator. Consider me if that's what parties agree to do. Now, key elements. The kind of collaborative arbitration that I've, well, actually, I should also give credits of this concept to the current deputy president of the International Dispute Resolution Academy, Jeremy Barley SC, because this article was actually co-authored by both of us. So the key elements, there are several of them. I would first perhaps point out the one of the key elements would be a contractual commitment and rule-based obligation that all parties involved in the arbitration should act in a spirit of mutual trust and cooperation throughout the arbitration. Now, again, how many of you have done NEC, have done construction arbitration, or are part of the construction sphere? Then you will be very familiar with this concept of mutual trust and cooperation, which is mandated in the NEC contract 10.2. So although it might sound a bit odd, strange to other practitioners in other general commercial arbitration, but I think it's something that's sounds quite familiar to construction specialists. And the second element, I would say, we propose that it will be the adoption of collaborative arbitration protocols that I mentioned earlier, which may include, for example, early warning and risk management mechanisms designed to give advance warning to the other participants of the arbitration, any potential issues that may arise, and potential delay, for example, in the resolution of the dispute in arbitration, so that solutions can be discussed and agreed before the issues escalate. And again, for those of you who are familiar with NEC 4, NEC 3, NEC contracts, you will feel comfortable with this because it's also, for example, the early warning mechanism is a key collaborative element in the NEC contract. So I guess that, the construction, the project management specialist will be perhaps find collaborative arbitration will be quite comfortable with this concept. And the third element that we propose are the payment arrangements. The payment arrangements are very important to make this whole collaborative arbitration work. The payment arrangements here, we are referring to those, financial motivations, that mechanism that motivate parties involved in the arbitration to act in a way that's better for the overall conduct of the collaborative arbitration. Now, what that means, for example, how the lawyers, right, will be remunerated, will be paid in the arbitration. I think that often has a profound impact on, the overall mechanism, the rules, procedures they advise the clients to adopt in the end. We will talk about that a bit further later. And here I will continue to go through all the key elements first. The next key element, we suggest that it would be the agreement between each arbitration participant to waive their respective right to sue each other for breach or negligence in the collaborative arbitration process. Now, again, that might sound a bit awkward or suspicious for some of you, or unfamiliar. Why would they want to do that? I suppose it depends on how collaborative or the extent of the collaboration that parties agree to adopt in a collaborative arbitration. And we will come back to this a bit later on as well. The next element, number 5, is the agreement between each arbitration participant to facilitate collaborative decision-making in the arbitration. Now, again, some of you may be pausing here, right? What? Decision-making process will be collaborative? Well, it's not necessarily, I would say, like a mediation, process. It won't go that far, but still, the purpose of this facilitative collaborative decision-making process is to make sure that the award will be performed. There will be no need to go through the enforcement stage, but the arbitral award could be, most likely will be in the form of a consent award, which can be executed with no problems in enforcement, for example, that will also cut down the costs and time, as we will further discuss. Then the next one is a proactive case management. I think this one is probably the easiest one for all of us to accept. Nowadays, I think proactive case management skills or expectation is quite high. Everyone expects that the tribunal will conduct the arbitration in a more time and cost effective manner, and proactive case management is a key to achieve that. Gain share, pain share. Now, again, that's a term that's very familiar to the construction industry, construction specialist, but less so in other industry, I believe. So this payment mechanism, again, is to facilitate, to make sure that the remuneration of the services provided in the arbitration can reflect the extent of the collaboration adopted in the arbitration.
When
So-
you put down the word gain share between who?
Between all the arbitration participants. So
Such as the arbitrator?
the arbitrator
Mhm.
as well. So if, for example, in a collaborative arbitration, parties have agreed that their common objective would be, as an agreement, is to render the award within 12 months, for example. Then if the arbitrator or the tribunal can render the award within the time limit, 12 months, then they will get a bonus uplift. But if they fail to achieve an award at the end of 12 months, then they will have to, maybe some deduction of their fees or discounted fees. That's what we are
That's
thinking,
what the
as an example.
Process that you know, control.
Absolutely.
Control evidence from the experts and how they agree or disagree as to that.
Yes, so it's not, of course, it can't be, we can't blame the delay to the tribunal, for example, on the tribunal, for example. But the idea is that everyone needs to work together. So the arbitration is a project. So everyone is working together to manage the project, the arbitration process in a time and cost effective manner, for example.
Because sometimes in such a case, the paying party, the respondent, whether it's the main contractor or the subcontractor to the main contractor, they may try to delay one of the parties
Yes.
to avoid having to pay out money, so they will drag on for as long as they can. So how does collaborative arbitration process work in situation like that?
Spot on, Samuel. I think that will be very hard when they don't have the same, the common goal of completing the arbitration in a time and cost effective manner. If that common goal is not there, then they don't have a basis for them to agree to conduct the arbitration in a collaborative manner. However, I believe that, if the NEC contract is involved, I still think that parties should conduct the arbitration in a collaborative manner, because after all, 10.2 is an overarching, obligation, commitment of all the parties in the NEC project or contract under the NEC model. So that term, that contractual commitment should go all the way to the dispute resolution stage, right? So you can't say, oh, we're only referring the mutual trust and cooperation to the delivering the operation of the project, but not when we are in dispute. So I think there are arguments to say that actually, given that, it's a 10.2 is a, the first and the utmost, most important contract obligation, it is required, it's a, requirement, it's an agreement under the contract that you should also conduct the arbitration or dispute resolution process in a collaborative manner. So I think the last point on this slide is the flexibility. So it really depends on how collaborative, the parties want to conduct the arbitration. I imagine there are cases where the parties do have the common objective to, just to go over the process very quickly, in a time and cost-effective manner, so that everyone can move on, for example. So it really depends on the extent, how collaborative they want, and they can craft their own collaborative protocols to meet, those collaborative agenda. So then we quickly talk about the advantages of collaborative arbitration. I think the starting point, of course, is to encourage collaboration and harmonious dispute resolution through innovation. Under the adversarial model, frequently, I think, Samuel, you just pointed out, right? So one of the parties, they want to drag on. So they want to deploy every tactic available to win at all costs. So they could push, blame to each other, to the other side, to the other arbitration participants. And so often the outcome would be the costs and delays are escalated, and lots of things could go wrong. I think that the adversarial model often results in unreasonable and sometimes unbearable delays and costs in the arbitration. And I think, generally speaking, in Hong Kong, of course, there are exceptions like documents-only arbitration, right? Those are exceptions. But generally, I think an arbitration would cost at least 18 months, right? Quite optimistic. And I don't know, 20 million easily can run off that, right? 10 million easily. The inclusion of a contractual commitment to collaborate and a no-fault clause that we mentioned earlier would help remove the incentive to resort to those tactics and motivate all participants to collaborate in pursuit of increased time and cost efficiency. So I think those are the advantages that are quite obvious, I hope. Yes.
This is good faith mediation negotiation before taking the step to arbitration.
Absolutely.
So there are. If you design certain steps and agreements as to this, what has to be taken on in the step of good faith mediation or negotiation, wouldn't that be similar to collaboration?
I think there are overlaps. Thank you, Samuel. That's an excellent question. I certainly think there are overlaps between mediation or even ARB, the one, now very popular, for example, in Singapore, the ARB protocol. So there are overlaps, but I think that what we are proposing, the collaborative, the concept of collaborative arbitration is really focusing on management, treating arbitration as a project and to enhance the project management skills. I think I was just really inspired by this NEC, mutual trust and cooperation mindset to conduct the arbitration, to manage the arbitration as a joint project, as a one team. Let's do this so that we can achieve what the clients want. The clients want to finish this in 12 months, within these time frames. So let's do what we can to achieve that. So the advantages here, again, time and cost saving from working collaboratively in managing the arbitration process. Collaborative arbitration aims to deliver the arbitral award. So really it's to deliver an award in a shorter time frame and at lower costs than traditional arbitration. Early case management mechanisms allows procedural or substantive issues to be managed collaboratively at an early stage. And again, that will result in significant less time and costs in producing the award. I think the last point is the non-adversarial approach will aim to result in lower costs for the parties compared to the adversarial model, where in arbitration participants might typically deploy delaying tactics, otherwise prolong the arbitration process. I think we already covered that. Yeah, there are a few more here. So in terms of the reduced costs associated with the ancillary and interlocutory, or even post-arbitral award proceedings, right? So we mentioned, for example, if parties can discuss those potential, issues that then hopefully they could avoid interim measures, or emergency arbitration, for example. Those are very costly processes. And the post-award enforcement, costs and time can also be saved. Collaborative arbitration protocol, right? So I think that seems to be the key. So what kind of protocol that we can or the parties can agree upon and can implement on those rules that aim to manage the arbitration process in a way that reduce the need to resort to those interim measures and emergency arbitration and all that. And so this may also reduce costs associated with the, I already mentioned, right? So the interim measure and all that, and non-enforcement, the post-award stage. So I think the last point really is about, sorry, can you see it? It's too small, isn't it? The text, but feel free to drop me an email, then I can send this to you if you are interested. The last point really is about the internal costs as well. So if we could manage the arbitration process conducted in a collaborative manner, then we are more likely to reduce internal costs associated with adversarial arbitration administration, which, for example, typically will require keeping a very detailed, proper trial to prepare for the parties, positions post-arbitration proceedings, like the resist, of enforcement and all those. And so those associated costs can all be reduced. Then we are quickly, just to summarize, I think this touches upon the flexibility we mentioned earlier. So it's not a black and white or a fixed, protocol. The parties are free to adapt. They can decide, how collaborative they want. They can, for example, they can simply agree the agreement, the collaborative, will be oriented by achieving an award within 12 months, for example. Then everyone will have to gear up to that. So I think that that encourages, discussions about effective management of the arbitration process from the outset. And I think particularly when you have a larger scale, multi-party, multi-contract arbitration, that flexibility is very important. So then let's have a look at the disadvantages. The disadvantages, we mentioned earlier one of this so-called no-fault clause. The no-fault clause, right? So I think that there are some potential issues there. So because what we were envisioning or proposing is that in a collaborative arbitration model, where the entitlement of each non-party participant to its gain share, payment depends on the performance of other participants, right? As we mentioned earlier, then any defective performance or non-performance by a participant of their collaborative obligations would also lead to other participants suffering financial loss. So, for example, who is there to be blamed if the collaborative arbitration failed to achieve, the milestones or delivery of an award within the time frame? Then everybody will lose their bonus, right? Their uplift. And can they sue each other for non-performing? Well, you didn't provide the evidence within the time frame, and you were ambushing us at the final hearing, for example. And all those, I think it will be quite difficult from lawyers and especially litigation arbitration lawyers' perspective. So if there is a no-fault clause, then the other participants may not have any recourse against the non-performing participant. So I think that no-fault clause could be difficult, but if in some circumstances might be possible. And then we have a quick look at other disadvantages. For example, this so-called no guarantee cost savings. Although we mentioned that the idea is that if we can manage the arbitration process collaboratively, so hopefully we can then achieve time and cost savings. But I think it also depends on the payment mechanism, right? So if the payment, for example, the lawyer's fees, if the lawyer's fees are tied with the outcome, say percentage of the disputed amount, right? Then that could be a very substantial sum, which could, may well, supersede, exceeded the hourly rates mechanism that we are more often seeing here, for example, in Hong Kong. So it really depends on how the lawyers, how the parties want to structure this collaborative arbitration. It's entirely possible if the clients want to have a very fast, very quick process, and the client is willing to pay, a percentage of the dispute to the lawyer. So, which I think is more common in continental civil law systems, for example, cross-border in the mainland. I think it's quite often the lawyers are charging, the fees based on the percentage of the disputed amount. So that might also be a reason why I would generally consider that continental law lawyers can be more collaborative or can be more reactively, considering or being persuaded to do the arbitration in a collaborative manner because their fees are kept anyway or percentage anyway. They want to finish this as soon as they can move on to other cases, for example, right? So I think that we can see there are some potential incentives there to help make everyone works towards a common goal in a, yeah.
Paying the legal team's ability to really fight the case for the clients. So they would just say, I'll just wrap it up and get my money.
Yeah, well, so
the arbitrators, tribunal members, I'm going to get this.
Just get over it. Yeah, I see your concerns there. I think that it depends on the agreement, right? The arrangement, the fee arrangements. Typically, I think I have seen in the mainland, for example, the agreements will be if, for example, the client will say, if you can help me to achieve this outcome, say a settlement sum that's above certain level, then I'm willing to pay you this as a bonus or uplift it. So it becomes a how to achieve the
It's a little bit like ownership time.
Yes, I think so. And it could be, so that could be also part of the elements or the jigsaws that would require or will help the parties to work collaboratively. So it's all about aligning the interests at the end of the day, I suppose, right? So some inhibitors of collaborative arbitrators: lack of familiarity. It's innovative. Yeah, it's just mainly inspired by the NEC, project management principles. So lack of familiarity, that could be really, that could be quite difficult, could be a hurdle. So it's very unfamiliar concept for many parties and participants, practitioners in international arbitration. But I think that we can see that there are scopes for its increasing utilization in, for example, construction industry internationally, and we can see that parties, practitioners, and arbitrators may be resistant to stepping out of their comfort zone in the more familiar, traditional adversarial arbitration model, where suitable. Embracing a different model. So that's the lack of familiarity surely is one of the hurdles. And the next one is the change in mindset. I think this also goes to, the same can be said for NEC model contract project management as a whole. So although we have already had NEC in Hong Kong for 15 years now, but still lots of, the mindset's not quite there yet. The collaborative mindset is not yet there. I think parties easily resort to, adversarial approach. So successful collaborative arbitration entails close cooperation between the parties and among all participants as they work towards the common goal and interest of achieving an arbitral award in a collaborative and time and cost-efficient manner. And this requires a change in mindset from that prevailing, traditional adversarial arbitration, where the focus is on parties acting solely to protect their own interests rather than focusing on common goals and interests. I suppose here you could also see that's why the parties are spending more money, because after they achieve an arbitral award in the adversarial model, they still need to do a lot, spend a lot more time and money on the enforcement stage, right? Because it's a win or winners win all, or losers lose all. So I think if the process can be more collaborative, that could really save lots of time and costs, including avoiding the cost in the enforcement stage.
Oh, in the construction dispute, many times costs are loaded front end. Or you start an arbitration, you will look at all the details, all the architect's instructions, all the instructions, variations, and so on. So actually, a lot of money already
Spent.
at the front end, rather
Yeah.
than the cost of the arbitration.
Yes.
So how do you say those costs necessarily spent?
I think it's hard, yeah. Well, in a perfect world, in an ideal world, I think the NEC model, NEC, contract management, project management, they are there to avoid dispute altogether, right? So if the PM, the project managers, has managed the project, has constantly, facilitating the parties using the mediator skills, they should have avoided any dispute from the project management, at the project management level. That would be ideal. But I think in reality, we are not there yet, right? Lots of the project managers, they were appointed, paid by the client, so their self-interest, they are less, neutral, or less facilitative. So that might be a good, I think could consider using a project mediator. So we have the PM, project manager, and then we appoint a project mediator. So the two of them can then work together to really avoid disputes and to manage the project in a more collaborative manner. So then so resistance, right? So it's very easy for us barristers. How could a barristers, sitting here advocating for collaborative arbitration, right? So we consider, right, this model might dilute or blur the hard lines between adversarial and non-adversarial procedures. And I think that in itself, for some of us, would find that very objectionable, or even one unworkable in principle. Yeah, that's what I'm trying to say, right? Resistance. Oh, sorry. I'm looking at next slide. The financial incentives, sorry. Financial incentives. I think it's very important. We already touched upon it earlier, right? So at the current adversarial model, I think that the vested interests, right, lawyers, benefit disproportionately from the current adversarial arbitration model. So those may be very reluctant to embrace or try a new model, which might affect their financial bottom line. So I often use this analogy. You will all remember it. I said, at the moment, the arbitration is like seafood buffet, right, for the lawyers or for the arbitrators. And mediation practitioners, they are like having vegetarian, okay? Although some people may be willing to pay more for vegetarian because it's healthy, it's more sustainable. And I think that's also some of, perhaps, leading to some of the difficulties we are now seeing. It's so difficult to persuade clients to go to arbitration because they know it's just money burning, process. And so I think that from the sustainability, point of view, there is a lot to say. Collaborative arbitration can potentially make the arbitration community more sustainable as well. Then the next one is the sufficient incentives should be built into the collaborative arbitration model to encourage all participants to achieve successful delivery of the common goal, whatever that's defined and agreed by the parties. It would be important to discuss and agree to a gain share, pain share, right? That payment mechanism that will provide sufficient incentive to arbitrators, lawyers, and experts to commit themselves to the collaborative model. So really, we're talking about looking at the arbitration as a project, okay? So it's managing the project together in a collaborative manner. Everyone works together collaboratively. So I was looking at this slide earlier, so the resistance principle, so we've already touched upon that one. So, some people, we just naturally think, that's not going to work. If we have an open mind, maybe we can try. The next one I want to quickly cover is the lack of mutual trust and cooperation. I think even for those in construction, right, under the NEC, we all know 10.2 mutual trust and cooperation, but still it's so difficult to actually do that. The parties and other participants in the collaborative arbitration are very likely to be skeptical of each other's intentions and actions, especially when they are already in a dispute, right? So parties may be reluctant to invest the time and effort needed to build or rebuild trusting relationships. Parties may not be prepared to share control and decision-making powers with each other and with the other participants in the collaborative arbitration. And I see those are all very understandably, hurdles. Okay, so then we've, talked about the advantages. We've also talked about the hurdles. So where are we then? And what do we see here? I think that at the present day, arbitration, we all know, has been really fraught with inefficiency. Immense disproportionate amounts of time and money are swallowed up in the process. So to name just a few, right, the commencement of the arbitration could take a few months. The appointment process for the arbitration tribunal can take another few months. The ancillary applications, interim measures, interlocutory application and all that. Emergency arbitrator procedures, right, again, another 6 months. Setting aside, even if you have achieved an award, you still have to battle in the post-award, non-enforcement proceedings. So I think that the user feedback on the current state of arbitration is invariably a plea for greater efficiency and reduced costs. The most significant cause of inefficiency, I think there are lots of causes. Some would be the disputes. They are complicated, right? So naturally they cost lots of money and lots of complex issues, lots of evidence involved and all that. But I think that there is also a very important misalignment, the issue of misalignment of incentives and objectives between parties and among the other participants involved in the arbitration. And I hate to point out, but I believe mainly the lawyers, right? So the lawyers are under lots of pressure. They have to feed the whole team, billable hours and all that. So if the lawyers can be remunerated, can be given the financial incentives to conduct the arbitration in a collaborative manner, then they will, okay? The lawyers will do that. So it's really to find that, to identify, to discuss and to agree to, that alignment. So really, I think the users of internet arbitration around the globe, right, will no doubt be able to see value in openness and shared common objectives in securing and delivering an arbitral award in a time and cost efficient manner. I think that's something could be easily understood and appreciated. Practitioners and neutrals in the arbitration field should take cognizance and of this, and likewise, right, I think it's really important to give proper consideration to the potential benefits of this alternative model and be prepared to promote and implement the collaborative model. And And also, I think reaping those benefits will require through, of course, preparation, implementation, and maintenance regarding the drafting of the model collaborative arbitration clause, the suitable set of opt-in collaborative protocols, rules, right, for widespread use. So I think if the collaborative arbitration model were to develop, at the moment, it's really just a, fantasy, perhaps, fans' fantasy, thrive. So for this fantasy to develop, to thrive and outgrow its niche status, limited to construction arbitration maybe, the arbitration industry should see more usage of this model, particularly internationally. And to end, I want to share this slide. So actually, in the West, we have also seen this very well-known quote for Churchill: "To improve is to change. To be perfect is to change often." I wonder what would happen if Mr. Churchill met our Monkey King in arbitration. We know Monkey King is very good at changing, adapting, and transformation. And that will be the end of my presentation tonight. And thank you. Thank you so much.
Can I have a word?
Please.
I still remember from 20 plus years back when New Kaplan was sitting as a construction judge, and there was a litigation case in construction, and you reminded the parties to cooperate and not to be too litigation oriented in resolving the dispute. But then the process still remains the same. And so you still need to fight about discovery, you still need to fight about the produce separate expert reports and so on and so forth, resulting in the award. Now, what protocol would that be in terms of a collaborative arbitration that is different to the usual steps taken in the normal arbitration? What are they? Are they thinking as to what to do, what structures, what kind of requirements that will make it different?
That's $1 million question, isn't it? I think that to start with, right, let's all consider. You rightly pointed out, I think the original idea, well, I don't know, at least half a century ago, the advantages of arbitration, one of the advantages is precisely the flexibility, right? You don't have to follow all the strict evidential rules and all that you otherwise have to follow in court. So that we've been telling the clients how attractive, that makes arbitration so attractive, so flexible. But I think that in recent times, we're not seeing that much. And especially when you have both parties represented by KC or, senior counsel, and the tribunal, 3 members are all, lawyers, barristers. And so I think that their expectations, perhaps, right, in the process is to do this in the way that they are most comfortable, they're most familiar with. So to encourage them to do something differently, other than what I mentioned about the financial incentives, okay, we need to address that, I think. Without addressing that, without identifying the balance, the alignment of all the interests, you can't expect lawyers not, fighting on every potential arguments. And it's also a way to protect themselves and protect the clients, right? So unless you can put all those considerations into this protocol that we are all wondering, I think it's going to be a long way. But let's talk about that. Why can't we form a interest group? Right? We can have a Hong Kong Institute of Arbitrators interest group on collaborative arbitration. Let's propose to the world, to the market, that these are the potential collaborative protocols that people should consider, or, institutions could consider, ad hoc arbitrators could consider. We can do that, right? I think so. If, Samuel, let's do it, right? We can work together, put together a collaborative arbitration protocol study group or interest group. Oh, I see that there are questions here. Whether you support the concept of collaborative arbitration and will consider adoption of collaborative arbitration in your practice. Oh my goodness. It's all yes. Amazing. Unbelievable. Yes. Thank you. Yes.
Could I just say something from the perspective of which I could echo Samuel in terms of deal capital. So deal capital 30 years ago, I was in court testing family key introduced mediation and family mediation is very active. And to use your analogy of the vegetarian, it used to be that litigators were carnivores and mediators were vegetarians. Partly from a realistic point of view, that is a cost element. But the interesting thing in the family world now is lawyers are fully engaged in mediation. So that as either mediators or in the mediation process. And the irony is that mediations will never, it's not cheap, it may be less expensive to trial, but it's still, one for better expression, does not break the iron lifestyle of the litigator, because instead of sitting in court, he or she is sitting in the mediation. And the experience of the family law, and we're talking not only just children cases, mega ancillary relief, that it's now being seen as, that I was mentioning this earlier thing. Certainly I was at a conference in Singapore last week, and the reference was that rather than alternatives, it's a program, and mediation is a real role for that. And just by reference to collaborative, and forgive me for going on my law, there is collaborative law in approach in family law. But the interesting approach for collaborative law in family is that the parties sign an agreement, and it's an agreement where both parties sign up and their lawyers. And that agreement is that if they do not settle, the clients have to find new lawyers.
Yeah.
So that incentivizes, for want of a better expression, the lawyers in reaching an agreement. And it has some traction, and not great traction, because of course the concern of the lay client is, well, what happens if I don't settle? Then all the costs I've spent, the wasted amount of time, new lawyer, and if I've been working with a lawyer for 6 months, I don't really want to find a new lawyer. So it has some traction in some areas, but not great. The equivalent arbitration in family in Hong Kong, there's been one case, although it's quite popular in the UK. I think one of the reasons why it's not popular in Hong Kong is because it's very difficult to appeal. So probably the most attractive way for dispute resolution in family is mediation, and in the last few years that has moved from facilitative to evaluative mediation. And that's very attractive because for all the obvious reasons, so that and the success rate is high, so it's well over 60%. So now we're getting to the situation that we're one of the most busy jurisdictions, that the concept of appropriate dispute resolution is very high. So if I may say, pick up on it's taken 20 to 30 years for the practitioners to come to terms with that. In fact, the court is the last alternative. But in addition, and I think it's the lay client to appreciate that actually going to mediating doesn't mean I have a weak case. You know, the classic story. The lawyer says, the solicitor says, I think you should mediate. And the client says, you obviously don't believe in my case. I'm going to go to another firm of solicitors. And I speak as a former solicitor. So there's always that concern. But one of the attractions, I think, is a real appreciation in the marketplace of the advantages. And so it's just a question, for want of a better expression, education.
Thank you, Robin. Thank you so much for bringing up the family law practice. And indeed, I think that's one of the examples that we've looked at when we were writing that article, and we also make reference to family practice. The collaborative practice is the norm, as I understand, particularly in Australia. It's, you know,
The norm,
a norm in, so all the practitioners are required to practice family law in a collaborative manner. They have family law practitioners requirements.
danger of using it collaborative. That is a noun as opposed to a collaborative practice. Yes, there should be, but I think there can be confusion between collaborative as a noun of an organisation and collaborative as working.
Right. Yeah.
So I mean, it's quite important. So
Sure.
I don't. Whereas family practices tend to work together for obvious reasons, it's if I may say so, potentially inaccurate to describe that as collaborative, because there is a very distinct collaborative group, and you could be a collaborative practitioner. As I say, if you're going to have family use the noun, then you have to sign up to a specific agreement, which means if you don't agree,
You'll have to fire your lawyer.
It's dangerous to use it in a
Broader sense, yes. It's only for family law. And I think that you also mentioned the mediation, although the evaluative mediation would be, I think, getting, resembles closer to arbitration in a way, because it's evaluative, telling the parties, it's, if you ask me, I would think, who is right, who is wrong. You are likely to get less than if you ask me to write a judgment, for example. So those evaluative approach, it's still a sort of making a judgment, so to speak, and in the past, right?
Except it's within mediation, so the mediators can't judge or make a decision. So it's very different arbitration, but it's the importance is it is a development from facilitative mediation. The point being, I think, that as mediation has matured, very often parties will say to the mediator, so you've heard this, you've heard us. So
what do you think?
So
Yes.
it's really a neutral evaluation. That's, I think, becoming more and more popular.
That would, so I can speak for another hour on mediation, and I'm a supporter of facilitative mediation. The mediation model, I think nowadays, and even in the mainland, if you ask anyone about mediation, typically they would say, "Oh, I know mediation. You compromise, I compromise, and then then we can settle, right?" So even in the speech by Wang Yi, 他的那个六尺巷, right? That story. 什么叫六尺巷? So for him, mediation is you give a 3 and I give a 3 inches, and together we have 6 inches. But that's really not the modern, international facilitative mediation that we are talking about. In a facilitative mediation, we want to spend time understanding each other's concerns and interests. We are not just looking backwards, looking who's right, who's wrong, what happened in the past. We are forward looking. What do you need? What can be done to fulfill your needs and concerns? So both parties can win. So you don't have to give a 3 inches. You don't have to give a 3 inches. Maybe somewhere in the corner we can find a way. that can fulfill both parties' interests and concerns. Well, it really depends what their needs are, right? And what their concerns are. Maybe one of the neighbors want to have a swimming pool in the front, and the other side want to have, the other, would prefer a backyard, a forest at the back. So you could perfectly find a way to fulfill, those interests and concerns. So
In terms of collaborative arbitration,
yes.
do you think anything about non-binding expert determination part of the process? Just like Robin was saying about evaluative
Absolutely.
mediation, so that parties would be more aware of
Yeah, I think so.
likely outcome.
Well, for example, right, in an intellectual property right dispute, right, if the dispute really, focusing on the right, right, whether that's a patent or not, this kind of dispute very difficult to mediate. It's just whether it is a patent or it's not, right? So if the parties wanted to do this in a collaborative manner, they could agree to, for example, introducing or having an early neutral evaluation mechanism and finding an expert, a typical IP senior counsel, and who can say, well, this is more likely is a patent or it's not. And then based on that, parties can then negotiate on their how to do the licensing, how to settle, how to develop the markets together. Right? Yes.
I have some questions about collective protocol that you mentioned. I think the contents can be improved with some interlocutory applications, such as I think interlocutory application may be inevitable because of security of call for calls and also discovery. So how would they be dealt with? Can it be covered in the collective protocol, because it may be served as such kind of international best practice like the IBA taking evidence, the rules of taking evidence on conflict of interest.
Yes.
I think it can be further developed and promoted as some kinds of international best practice internationally. Yeah.
I think so. I think it's, so once we are focusing on interests and concerns, the options, the solutions are endless. There are so many ways to fulfill the interests and concerns. But if we are entrenched, so really focusing on just the position, who's right, who's wrong, there is only one answer, the one way, right? So if, for example, in a case where security is a concern, then I think most likely one of the parties would need to voluntarily offer that I put down money here and let's do this collaboratively and resolve this and let's go and make money together, for example, right? So it's really about understanding the interests and concerns and then how to deal with that and find solutions together. And solutions are always, you always find more solutions than problems. Okay, thank you so much. Yes, Raymond.
Also, I have two observations from me. And some of you may know that in the recent PRC leading arbitration rules, they introduced the concept of good faith cooperation in the conduct of arbitration. So I wonder, whether it may be, too ambitious for us to introduce a new concept of collaborative arbitration, but it may be easier if we can coordinate or work together with the current mechanism and the current arbitration rules. For example, the good faith obligation I just mentioned, and also in most of the arbitration rules, they have the expedited procedures. So I just wonder, whether we can really try to work together with the current mechanism to say good faith, basically, the fundamental principle for your the theme of the collaborative arbitration, and also for the activity procedures, if not that people see the problem of increased cost and time for arbitration. So that's one way to deal with these problems, and what we can really to work out some kind of options and soft laws to deal with this problem. Just maybe two observations from
Yes, I think I totally understand. I think I have also I'm also aware of this good faith obligation in some of the arbitration rules in the mainland. I think it's much easier for continental lawyers, mainland lawyers, to accept that. They have no hesitate, they fully subscribe to that. But for common law lawyers, for lawyers in Hong Kong, in England, Singapore, Australia, good faith is like wild horse, or how to describe it, right? Good faith is at the moment you mentioned good faith, I think people are getting, a bit worried or concerned. Although we are not saying that good faith doesn't exist in English law or common law. That's not the case either. It's just that English law, Hong Kong law, we have dealt with, we have used different methodology to achieve the same outcome. So implied terms, for example, we use implied terms. We're using more concrete cases, for example, to maintain the predictability. While in the mainland, they use codified methodology to hopefully to achieve the predictability. But I think that this can all be discussed and done. So if you have two continental mainland Chinese lawyers, law firms representing the parties, I don't think they will be having any problems. In fact, they might be more comfortable with the inquisitorial style tribunal, right? So they will be naturally collaborative when the arbitrators say, I want to see this, I want to see that, right? They are naturally collaborative. I think in the adversarial system, however, I think that's where we are hoping just to giving, some thoughts, considerations to collaborative manner or consideration so that we can run the arbitration in a more time and cost effective, way. That's all. Yeah. So, but I think that all can be discussed and can be done. And it's really up to the parties and maybe the arbitrators as well. I think maybe we can have a collaborative arbitrators association. Samuel. Thank you. Thank you so much. Yeah. Yeah. Okay. Yeah, we have some questions here. Set up a working group to devise protocols for collaborative. Yes, so I was asked whether we are going to set up a working group. Let's do that, Raymond, Samuel, yes. So not just me, but Hong Kong Institute of Arbitrators. We are going to do that, right, Samuel? We've been asked. Oh. Samuel is on. Oh, someone cannot hear you, Samuel. Sorry. Sorry, Robert. Are there any statistics to support use and desirable outcome on the basis of collaborative arbitration? No, we don't have any statistics. Sorry, it's all innovative. Not yet, not yet. Collaborative arbitration would work well for those small arbitrations, which fall outside the forthcoming SOPL, the security of payment. However, the problem will still be well, okay. Well, I think that the idea of having a collaborative principle or to collaborate in the project management, such as the NEC, model of contract. I don't think that collaborative arbitration would necessarily be limited to smaller arbitration. Could be quite on the contrary when you have 10 subcontractors, right? Or you have a mega, a big dispute. I think in those complex, multi-party, multi-jurisdictional arbitration, if the parties can work collaboratively, they may well save the arbitration. Otherwise, the parties would have given up, without even commencing the arbitration. Just a thought. Why should arbitration practitioners trouble themselves with this new model? Because the answer is not simply that the reasoning behind the proposed collaborative model is aspirational. Yeah. The adversarial model, and that the financial incentive might be found attractive by practitioners, but also, and importantly, that the growing and vocal, for instance, end user dissatisfaction, to stay ahead, right, before it's too late, Yeah, very well said. So as to preserve the health of the entire arbitration process and the arbitration community, sustainability, we mentioned that. Totally agree. Yeah. Yeah, I think so. So the last sentence was the end users will drive change as they get more and more fed up with the state of adversarial arbitration practice. Are there any statistics to support you? Sorry, no statistics. Sorry. Okay, that's it. But hopefully we will see more. We can certainly start the conversation, the discussion on this interesting topic. Okay.
And actually, there may be lesser arbitrations or litigations in construction cases with the oncoming of SOCOM.
Mm,
So actually, each of the dispute part of it in terms of interim payment will be decided month by month.
mm.
Some of the disputes and resolved.
Yeah, and in fact, I think that because I'm also I'm a FIDIC certified adjudicator, so I think that the adjudication can also work quite well if the parties collaborate in the adjudication process. In fact, given that it's such a fast, rough process, it's all the more important the parties do collaborate so that they can achieve something in the adjudication. So, okay. Thank you all. Thank you all so very much. Thank you for those joining us online. Hi.
I can invite all, our participants to take photo with the